In May of this year, the Court of Appeal decided against Alberta in an impaired driving case and ruled that our province's current legislation is unconstitutional. Specifically, the court stated that suspending a license until a matter is resolved in court infringes on an individual's charter rights. The defendants in the case argued that suspending their licenses until the case gets resolved results in innocent people pleading guilty just to get their license back. The court decision stated that drivers may be induced to surrender their constitutional right to the presumption of innocence. Our government has decided we will not be appealing this decision. Between 2012, when Alberta's current impaired driving legislation came into force, and 2015, our most recent verified data, there have been 311 fatalities from alcohol-involved collisions. This means that we can do better. Drinking and driving imposes enormous costs on our society. The greatest impact is on victims and families who have lost loved ones. Every one of those victims has family, friends, and colleagues to mourn them. Unfortunately, impaired driving remains the leading cause of criminal death in Alberta. Deaths caused by drinking and driving are senseless, tragic, and 100% preventable. As we move forward, we will be looking at other legislative models across the country to see which models and which initiatives have been most effective in saving lives, reducing injuries, and improving traffic safety. We want to ensure that our laws reduce impaired driving while also being upheld in court. The court is allowing the current sanctions to remain in place until May of 2018, which means that police officers can still suspend licenses in impaired driving situations now. We will need to have ongoing conversations with many different partners about the changes to the legislation before it's brought forward. New legislation will be introduced before the deadline.